Private information is in there. The National Crime Information every day for legit investigations. Use it for personal gain. The invasion of your privacy becomes a crime. As 90 Wants to Know investigator Jeremy Hohola found, cops who didn't escape the consequences.
Buttons on a keyboard. Keys to the gate of your privacy. With a flick of their fingers, cops instantly get on you what the public can't.
I was angry.
Like the case of this woman worried about retaliation. An anonymous letter came in her home mailbox saying, "You better quit driving like a maniac," and Denver police has you on scanner.
I was really concerned. It scared me.
Investigators found a mechanic, not a cop, got her home address from the federally protected database known as NCIC. The mechanic didn't like the woman's driving, so he got his cop buddy, Denver officer John Diaz, to run her plate.
For a long time, whenever I would walk outside of my house, I would look around just to make sure that things seemed okay.
This is very sensitive information. It's not a toy, and it can't be abused.
This guy was caught looking up his ex-mistress after getting a restraining order. This cop looked up a woman, but instead of getting a date, he got caught. This detective gave NCIC information to his girlfriend who wanted dirt on her boss. We could go on and on. 105 NCIC abuse cases in Colorado over the past 5 years. That number seems pretty small when you consider 20,000 people in our state have access. Either that number tells us abuse rarely happens or it's rarely caught. What is common? Cops avoid criminal charges. NCIC misuse is against the law, correct?
It is. There is a violation.
NCIC abuse is against the law, correct?
It is against the law, but there's a lot of things that are against the law.
We want to know why police rarely get charged when they illegally tap into NCIC to invade your privacy. We could only find 2 Colorado cops charged over the last 10 years. Is it okay for police to use NCIC to find dates?
No.
Is it okay for police to look up ex-girlfriends?
Not at all. It's absolutely inappropriate.
Can police use it to look up family members?
Nope. NCI is pretty clear what you can and cannot do.
Can police use it to help their friends get revenge?
Nope.
So you acknowledge that NCIC abuse is against the law?
No question.
Okay. So why weren't any of these officers in the 25 sustained cases charged?
Well, again, it's a decision for the district attorney whether to charge anybody. Deputy Chief Matt Murray says the system handles police differently because when they break the law, they will face stricter punishment at work compared to private citizens. Discipline action like a suspension goes on their permanent record. That's often enough, he says. It's not an excuse. What I'm saying is we are somewhat unique because an officer faces double jeopardy in everything they do. They could face criminal charges, but they definitely face departmental sanctions, and sometimes those sanctions are much higher than people think.
This is like any other internal affairs investigation. When you have the police investigating police misconduct, it generally goes pretty well for the police.
Civil rights attorney David Lane calls the double jeopardy claim absurd.
Absent some outside independent investigative body, the police will always whitewash any misconduct that they engage in.
I think you really need to look at each incident.
CBI's policy relies on police agencies to police themselves when misconduct is found, but 2 years ago they were requested to officially investigate one person. But that person was not a law enforcement officer, that was a state employee.
State employee, correct.
So people hearing that may ask the question, well, there you go. You have a law enforcement officer not facing charges, but then here you have a state employee facing charges.
Yeah, I would have to believe that each agency is taking the necessary steps to take appropriate action.
Out of 25 Denver cases we reviewed, 1 firing and 10 cops lost 1 or 2 days' pay, but most received a written reprimand or a firm scolding.
This is clearly an instance where, or a window into what I think is probably a more widespread problem than maybe we think.
The local ACLU hopes Denver police re-examine NCIC discipline.
We haven't found that there's been enough stringent discipline imposed on at least the abuses that we know about.
No, definitely insufficient.
For the woman who got that nasty note, she feels police are sending a different message.
You know, I don't trust law enforcement like I used to, definitely. I don't feel the trust that I used to feel for them.
And to their credit, Denver police have actually been quite transparent, revealing the names of officers and circumstances surrounding NCIC abuse. Other agencies, though, like Colorado State Patrol, will not turn over such information, saying they don't want to subject officers to the trial of public opinion. Ironically, they are protecting the privacy of cops who violated someone else's privacy. Kyle?
They are not going to be happy that you pointed this out. Somebody's looking you up right now, I'm telling you.
Oh, maybe.
Is anybody involved in this realm calling for changes in procedure?
Yes, back in March, the Denver Independent Monitor called for stronger penalties for NCIC.
COPWATCH, from checking up on ex-mistresses to getting dirt on a girlfriend's boss to trying to get a date, 9 wants to know found Colorado police often avoid criminal charges when they illegally access law enforcement databases for personal reasons. After an extensive review of discipline records, court documents and other public information, 9 wants to know found far more misconduct cases compared to cases resulting in prosecution. The database is protected by law. The National Crime Information Center (NCIC) and Colorado Criminal Information Center (CIC) are important federal and state databases police use during criminal investigations. They contain loads of private information on citizens like private phone numbers, addresses and property information. Using NCIC and CIC without valid reason is considered a crime under respective federal and state laws. However, officers who are caught abusing the systems are rarely charged. We haven't found that there's been enough stringent discipline, at least on the abuses that we know about, said Denise Mays of the Colorado ACLU. It is not a toy and it can't be abused. Related, see specific examples of NCIC violations. The numbers. Over the past 5 years, the Colorado Bureau of Investigation documented 105 sustained NCIC misuse cases across the state. 9 wants to know could only find 2 cases of law enforcement officers being charged over the last 10 years for violating NCIC rules and those were federal cases. Out of Denver's 25 sustained cases over the past 10 years, most officers received a written or oral reprimand. 10 officers also lost up to 1 or 2 days' pay. 1 officer was fired. None of those DPD officers were criminally charged, including former cop Daniel Donahue, who looked up his ex-mistress after being accused of holding a gun to her head in a restraining order. A COPB spokesperson said about 20,000 people currently have access to NCIC. A victim's perspective. I was angry, said a Denver area woman whose privacy was violated. She spoke to 9 wants to know on the condition her name wouldn't be revealed. The woman received an anonymous, handwritten letter to her home, claiming she was on a police scanner and that she was driving like a maniac. The letter threatened she would be ticketed. For a long time I would walk outside of my house. I would look around, just to make sure things seemed okay, she said. Discipline documents reveal a mechanic obtained the woman's address after he got his cop buddy, Denver officer John Diaz, to run her license plate. Diaz received a written warning in the case. I don't trust law enforcement like I used to, the woman said. Other NCIC abuse victims declined to speak to 9NEWS, fearing retaliation. Police perspective, we are somewhat unique. It's wrong and we deal with it, said DPD Deputy Chief Matt Murray. He said such criminal charges would be up to the district attorney. Murray said the judicial system views police differently because they face stricter punishment at work compared to the average citizen. Murray said current internal discipline surrounding NCIC abuse is reasonable, because even a written reprimand can go on an officer's permanent record, preventing promotions. Extended interview, NCIC abuse. It's not an excuse, but we are somewhat unique, because an officer faces double jeopardy in everything they do, Murray said. They could face criminal charges, but they definitely face departmental sanctions, and sometimes those sanctions are much higher than people think. The Colorado Bureau of Investigation, which is responsible for overseeing chick use in Colorado, has a policy of relying on home law enforcement agencies to handle chick discipline. A spokesperson for COPB said, typically, they would only launch a criminal investigation against an officer if they are requested by an agency to do so. You need to look at each case on its individual basis, said COPB spokesperson Susan Medina, who echoed Murray's reasoning. When asked for how many people have been criminally prosecuted for chick abuse under COPB's investigative authority, Medina provided one example of a state employee who was charged in 2014. That employee was not a law enforcement officer, she said. When you look at the full spectrum of actions that are available to a law enforcement agency, I would have to believe each agency is taking the necessary steps to take appropriate action, Medina said. A spokesperson for the Denver District Attorney's Office said it reviews the egregiousness surrounding an chick violation, but that a state criminal charge may not be filed if a harsher or more appropriate penalty comes from administrative discipline. Spokesperson Lynn Kimbrough could not say if her office reviewed any of the DPD officers with sustained violations, claiming they don't have a way to look up anything on cases we may have reviewed and declined. It would have to be a labor-intensive manual search of paper refusal slips that are in folders, chronologically by date. The Independent Monitor, tougher discipline needed. In March, Denver Independent Monitor Nicholas Mitchell called for stricter discipline against DPD officers after his review of the 25 sustained cases involving chick abuse. Each case risked potential harm to the reputation of DPD officers as trustworthy public servants, and in one case, the improper disclosure of chick/sick information created the opportunity for possible criminal behavior by a vengeful spouse, Mitchell's report said. Mitchell's call was met with no change in the discipline matrix, which outlines what kind of sanctions an officer receives depending on a policy violation. Deputy Chief Murray said at this current point in time, the discipline matrix reasonably handles chick discipline, what at its initial state is a Level 1 violation. Murray stressed officers will often face stricter discipline for matters far more egregious than an chick lookup. It depends on how officers uses the information, Murray said. If somebody uses that information at a greater level, that's going to prompt a bigger response. Civil rights advocates. This opens a window to what is probably a more widespread problem than maybe we think, said Denise Mays of the local ACLU. I think a lot of us take too much comfort in the fact that this information is safeguarded, because that's what the government and that's what law enforcement, tell us all the time. Mays said she hopes the Denver Police Department will re-examine its discipline surrounding chick abuse. Outside some independent investigative body, the police will always whitewash any misconduct they engage in, said David Lane, a civil rights attorney based in Denver. This is like any other internal affairs investigation. When you have police investigating police misconduct, it generally goes pretty well for the police. Copyright 2016 CUSA. National Crime Information Center (NCHIC), National Crime Information Center Criminal Justice Information Services, GIS, Division 1000 Custer Hollow Road, Clarksburg, West Virginia. 26,306 hours of service, 9 a.m., 5 p.m. Telephone, 304-625-2000. NCHIC is a computerized index of criminal justice information, that is, criminal record history information, fugitives, stolen properties, missing persons. It is available to federal, state, and local law enforcement and other criminal justice agencies and is operational 24 hours a day, 365 days a year. Purpose: The purpose for maintaining the Ncis system is to provide a computerized database for ready access by a criminal justice agency making an inquiry, and for prompt disclosure of information in the system from other criminal justice agencies about crimes and criminals. This information assists authorized agencies in criminal justice and related law enforcement objectives, such as apprehending fugitives, locating missing persons, locating and returning stolen property, as well as in the protection of the law enforcement officers encountering the individuals described in the system. Access constraints. All records in Ncis are protected from unauthorized access through appropriate administrative, physical, and technical safeguards. These safeguards include restricting access to those with a need to know to perform their official duties, and using locks, alarm devices, passwords, and/or encrypting data communications. Use constraints. Users of the Ncis system will be restricted to only those privileges necessary to perform an authorized task. Agency program. The FBI is authorized to acquire, collect, classify and preserve identification, criminal identification, crime, and other records and to exchange such information with authorized entities. Sources of data. Data contained in Ncis is provided by the FBI, federal, state, local and foreign criminal justice agencies, and authorized courts. The most recent iteration of Ncis became operational on July 11, 1999 at the FBI's Criminal Justice Information Services Division in Clarksburg, West Virginia. A recent hardware upgrade to the Ncis system is responsible for this significant improvement in performance. Categories of individuals covered by the system. A. Wanted persons. 1. Individuals for whom federal warrants are outstanding. 2. Individuals who have committed or have been identified with an offense which is classified as a felony or serious misdemeanor under the existing penal statutes of the jurisdiction originating the entry, and for whom a felony or misdemeanor warrant has been issued with respect to the offense which was the basis of the entry. Probation and parole violators meeting the foregoing criteria. 3. A temporary felony warrant may be entered when a law enforcement agency has need to take prompt action to establish a warrant entry for the apprehension of a person who has committed or the officer has reasonable grounds to believe has committed a felony and who may seek refuge by fleeing across jurisdictional boundaries and circumstances preclude the immediate procurement of a felony warrant. A temporary felony warrant shall be specifically identified as such and subject to verification and support by a proper warrant within 48 hours following the entry of a temporary warrant. The agency originating the temporary felony warrant shall be responsible for subsequent verification or re-entry of a permanent warrant. 4. Juveniles who have been adjudicated delinquent and who have escaped or absconded from custody, even though no arrest warrants were issued. Juveniles who have been charged with the commission of a delinquent act that would be a crime if committed by an adult, and who have fled from the state where the act was committed. 5. Individuals who have committed or have been identified with an offense committed in a foreign country, which would be a felony if committed in the United States, and for whom a warrant of arrest is outstanding and for which act an extradition treaty exists between the United States and that country. 6. Individuals who have committed or have been identified with an offense committed in Canada and for whom a Canada-wide warrant has been issued which meets the requirements of the Canada-U.S. Extradition Treaty, 18 U.S. C. 3184. B. Individuals who have been charged with serious and/or significant offenses. 1. Individuals who have been fingerprinted and whose criminal history record information has been obtained. 2. Violent felons, persons with 3 or more convictions for a violent felony or serious drug offense as defined by 18 U.S. C. Secretary 924 E. C. Missing persons. 1. A person of any age who is missing and who is under proven physical/mental disability or is senile, thereby subjecting that person or others to personal and immediate danger. 2. A person of any age who is missing under circumstances indicating that the disappearance was not voluntary, 3. A person of any age who is missing under circumstances indicating that that person's physical safety may be in danger. 4. A person of any age who is missing after a catastrophe. 5. A person who is missing and declared emancipated as defined by the laws of the person's state of residence and does not meet any of the entry criteria set forth in 1-4 above. D. Individuals designated by the U.S. Secret Service as posing a potential danger to the President and/or other authorized protectees. E. Members of violent criminal gangs, individuals about whom investigation has developed sufficient information to establish membership in a particular violent criminal gang by either 1. Self-admission at the time of arrest or incarceration, or 2. Any two of the following criteria: a. Identified as a gang member by a reliable informant. B. Identified as a gang member by an informant whose information has been corroborated. C. Frequents a gang's area, associates with known members, and/or affects gang dress, tattoos, or hand signals. D. Has been arrested multiple times with known gang members for offenses consistent with gang activity. Or E. Self-admission other than at the time of arrest or incarceration. F. Members of terrorist organizations, individuals about whom investigations has developed sufficient information to establish membership in a particular terrorist organization using the same criteria listed above in paragraph E. Items 1 and 2a, as they apply to members of terrorist organizations rather than members of violent criminal gangs. G. Unidentified persons. 1. Any unidentified deceased person. 2. Any person who is living and unable to ascertain the person's identity, for example, infant, amnesia victim. 3. Any unidentified catastrophe victim. 4. Body parts when a body has been dismembered. Categories of records in the system. A. Stolen vehicle file. 1. Stolen vehicles. 2. Vehicles wanted in conjunction with felonies or serious misdemeanors. 3. Stolen vehicle parts including certificates of origin or title. B. Stolen license plate file. C. Stolen boat file. D. Stolen gun file. 1. Stolen guns. 2. Recovered guns, when ownership of which has not been established. E. Stolen article file. F. Securities file. 1. Serially numbered stolen, embezzled or counterfeited, securities. 2. Securities for present purposes of this file are currently, for example, bills, banknotes, and those documents or certificates which generally are considered to be evidence of debt, for example, bonds, debentures, notes, or ownership of property, for example, common stock, preferred stock, and documents which represent subscription rights, warrants, and which are of the types traded in the securities exchanges in the United States, except for commodities futures. Also, included are warehouse receipts, traveler's checks and money orders. G. Wanted person file, described in categories of individuals covered by the system. A. Wanted persons, 1-4. H. and fugitive file, identification data regarding persons who are fugitives from foreign countries, who are described in categories of individuals covered by the system. A. Wanted persons, 5 and 6. I. Interstate Identification Index file, a cooperative federal state program for the interstate exchange of criminal history record information for the purpose of facilitating the interstate exchange of such information among criminal justice agencies. Described in categories of individuals covered by the system. B1. J. Identification records regarding persons enrolled in the United States Marshals Service Witness Security Program who have been charged with serious and/or significant offenses, described in categories of individuals covered by the system. B. K. Bureau of Alcohol, Tobacco, and Firearms BATF Violent Felon File, described in categories of individuals covered by the system. B2. L. Missing Person File, described in categories of individuals covered by the system. C. Missing Persons. M.U.S. Secret Service Protective File, described in categories of individuals covered by the system. D. And Violent Criminal Gang File, a cooperative federal state program for the interstate exchange of criminal gang information. For the purpose of this file, a gang is defined as a group of 3 or more persons with a common interest, bond, or activity characterized by criminal or delinquent conduct. Described in categories of individuals covered by the system. E. Members of violent criminal gangs. O. Terrorist File, a cooperative federal state